JFK 35 is a production of the JFK Library Foundation. The views, thoughts, and opinions expressed are the guest's own and do not represent the views, thoughts, and opinions of others at the JFK Library Foundation or the JFK Library, including staff, board, or donors. The material and information presented here is for general historical and educational information purposes only. The views expressed in the podcast are not meant to imply any endorsement of or opposition to any organization or political party.
The Constitution was written for an entirely different period in our nation's history. It was written under entirely different conditions, but all of its clauses, the general welfare and due process and all the rest, had to be interpreted by men and had to be made to work by men. And it has to be made to work today in an entirely different world from the days in which it was written.
The U.S. Constitution is the foundation of American democracy. For nearly 250 years, it has guided the nation through war, economic hardship, political upheaval, and moments of profound change, providing the framework that has allowed our democracy to survive.
This week, we're joined by historian Barbara Perry to explore the enduring importance of the Constitution and how presidents, including John F. Kennedy, have understood and upheld their oath to preserve, protect, and defend it. That conversation is next on JFK 35.
And so, my fellow Americans, ask not what your country can do for you, ask what you can do for your country.
Hello, I'm Matt Porter.
And I'm Jamie Richardson. Welcome to our special America 250 season of JFK 35. As the United States marks its 250th anniversary, we'll explore the ideas, values, and debates that have shaped our nation from its founding to the present day. This week, we turn our attention to America's founding charter, the U.S. Constitution. Drafted in 1787, it established the framework for a new democracy. While imperfect from the start, the framers designed it to endure and adapt, helping guide the nation through nearly 250 years of change.
Joining us today is Dr. Barbara Perry, presidential historian and co-chair of the University of Virginia Miller Center's Presidential Oral History program. She's also the author of the new book, Reconcilable Differences, The Unlikely Political Alliance of John F. Kennedy and Eleanor Roosevelt. Barbara, thank you so much for joining us.
Oh, thank you, Matt and Jamie. It's great to be with you, as always.
Yes, as always, thanks for talking to us again.
Great. Every president begins their presidency by swearing an oath to the Constitution and to, quote, preserve, protect, and defend it. Over the years, Barbara, how have presidents interpreted that oath when it comes to how they view it and understand the document?
I think to start with, most of them, I would say, take it very seriously. They know that this is in the Constitution itself, the oath, and that they are taking their and making clear their fidelity to the document, to the laws and the treaties made under it. And so not only do you can see, particularly in the era of television and recordings, the seriousness of purpose, you can see it in their face as they take the oath of office, usually from the Chief Justice of the United States. So that's the first thing that I would point to. The second is that virtually all the presidents we've ever elected, whilst they might want to expand presidential power, and they have, starting with George Washington, still are very seriously tied to the Constitution and typically don't deliberately violate it. Now, again, that doesn't mean that they don't have different interpretations of their powers and authority given in Article 2 of the Constitution, or don't have differing views from other presidents or chief justices or justices of the United States or the framers of the Constitution as to how to interpret the powers of the other branches. But we can be, I think, very grateful that, with some exceptions, if you'd like to talk about that as we go along, of presidents abiding by the Constitution and supporting it, even unto a civil war in the 1860s.
Well, as you say, most presidents have had some sort of common view. What are the common themes most presidents have understood about the Constitution? And I think, as you were alluding to, are there examples where presidents have taken sort of radically different understandings of the document related to their roles and responsibilities?
They typically take it seriously and know that if they go too far outside the bounds of either the Constitution's wording or it's having been interpreted by other presidents or interpreted by particularly the U.S. Supreme Court, that they could be on thin ice. Now, again, that doesn't mean that they haven't tried to move beyond that. But for example, the other two branches of government, they may get upset at how those branches of government are operating as it applies to them, or that they are countermanding something, or that the president wants to get something through the Congress, but he can't because his party is not in the majority in one or both houses. Or a president will take an issue and decide a policy, take an action, and it can be challenged all the way into the U.S. Supreme Court, and they can strike it down. So it doesn't mean that presidents are happy about that, but we've never really had a president who said, I don't follow the Constitution, I don't care about the Constitution, or have it interpreted by the Supreme Court and then not follow what the Supreme Court said. There's some issues about Andrew Jackson and the Indian Removal Act and that sort of thing involving some Indians in Georgia. There are some questions about that. There was a question about whether Richard Nixon, and by the way, he is the number one example of a president violating with abandon the laws and the U.S. Constitution. And he suggested that when the Watergate tapes were being challenged because he did not want to release his tapes that he had made that turned out to be very much against him because he had supported the cover up of the Watergate break-in and had started to try to get hush money to keep people who were involved quiet. He had indicated that even if the Supreme Court ordered him to release those tapes for those of his men, the president's men who were being tried criminally about Watergate, he suggested he might not follow the Supreme Court's decision. But when they handed down the decision in August of 1974, he did not only follow it, but then when his members of his own party from Congress came to the White House and said, you need to resign. And if you don't resign, you will be impeached, that is indicted, and you will be convicted, and you don't have our votes to support you, and we're the leaders of your party. So he resigned. So again, occasionally presidents will have a fight. FDR famously had a fight with the court over New Deal legislation that they were striking down, and he decided to have a court packing scheme. It never got off the ground, and we can talk more about that if you wish. But again, most presidents don't want to run into a situation where, one, they are viewed as a president who's not following our basic fundamental laws, that is the Constitution, and two, they don't want to be impeached and possibly removed from office if they're convicted, and they don't want to willy-nilly ignore the other two branches of government. And I would say that has held until the current incumbent, and particularly in his second term.
And talking about kind of getting to JFK for a moment, President Kennedy kind of had a historian's mind when it came to a lot of American history. And he didn't believe the Constitution was a static document. He said to students in 1962 participating in an internship program,
the Constitution was written for an entirely different period in our nation's history. It was written under entirely different conditions. It was written during a period of isolation. It was written at a time when there were 13 different units which had to be joined together, and which, of course, were extremely desirous of limiting the central power of the government. That Constitution has served us extremely well. But all of its clauses, the general welfare and due process and all the rest, had to be interpreted by men and had to be made to work by men. And it has to be made to work today in an entirely different world from the days in which it was written, both at home and abroad.
So from Kennedy's time, what did his view of the Constitution as an evolving document mean for his approach as president, especially in the era when he was in office?
Yes, from that very statement, you can tell, though he was a historian, some might say an amateur historian by virtue of not having a PhD in history, but having won the Pulitzer Prize for history for his book Profiles in Courage, about members of Congress who voted against their own political interest and then sometimes lost their seats, but they did the right thing in their minds. So he had a real sense of people doing the right thing. But he was not a lawyer. He was not an expert on the Constitution, but he had a very typical understanding in that time period, particularly the 1950s and 60s, of what came to be known in the 1980s, particularly by those who were against this, as a living Constitution. And Justice Antonin Scalia, who had a very different view of the Constitution, didn't believe it should be brought up to date, particularly by members of the Supreme Court. He'd say, I believe in a dead Constitution. So just so people get a sense that there are also two sides on what is called strict interpretation of the Constitution and then broader and more active interpretation of the Constitution. So I'd say President Kennedy falls on that living Constitution side of the spectrum and also on the broader interpretations that do try to bring it up to date, particularly by virtue of the courts. And it should be noted that his two appointments to the U.S. Supreme Court, Arthur Goldberg, who had been his Secretary of Labor and was an excellent lawyer, had been, was very well educated in the law, and then Byron White, also called Whizzer White, who had been a friend of President Kennedy going back to his days in pre-war London and had also served with him in the South Pacific. Actually, those two members of the court, Justice White tended to be a little more strict in his interpretation of the Constitution. Goldberg very broad and activist in his interpretation. So, in other words, I don't think President Kennedy had like a Ronald Reagan or a George W. Bush or even Donald Trump, a real hardcore sense of, I want people to have this view of the Constitution before I put them on the Supreme Court. I particularly like his approach, which is I want somebody who's well educated, who's qualified, that I believe in, and then let the chips fall where they may.
And going even further back from Kennedy, but how do you think the founders would have thought about if their document that they created should have been more of the living kind or the, quote, dead Constitution that you referred to?
I suspect that while some of them, like John Marshall, who was a little bit behind in age from the founders at Philadelphia, but he would be the fourth Chief Justice of the United States and is called the Great Chief Justice. And he was appointed by John Adams at the end of his term when he had been defeated by Thomas Jefferson. And so those two founders had very different views of the Constitution. As an example, it was thought by Thomas Jefferson that each of the three branches of government should interpret the Constitution as it applied to them for themselves, whereas John Adams was more open to having John Marshall create what's called judicial review, which is nowhere mentioned in the Constitution. You can interpret it out of the Constitution, but the exact wording is not there, and that allows what we now take for granted, that the Supreme Court and other federal courts can review, if a case comes to them, an action of the president, action by Congress, an action from the police officer in the street. And if they deem it to violate the laws or the Constitution, they can strike down that action from any of those actors. So I would say that the founders were split on that and ended up having two different political parties to start with based on a view of the Constitution that differed one to the other. So one were Federalists, one were Jeffersonians, or they were called then Democratic Republicans, just to confuse students forevermore, but really the basis of the Democratic Party. So again, I would think that President Kennedy falls, and certainly his brothers, and particularly Senator Edward Kennedy, who spent 47 years in Congress and was on the Judiciary Committee and voted for members of the federal judiciary and the Supreme Court for about, I think he voted for 30 or 40 members of the Supreme Court. And he would say, at least for the first 20 or so, he would vote even for Republican president's appointees as long as they were qualified. He didn't necessarily agree with them. Then as things got more fraught in that space, he kind of backed off from that. And if he didn't agree with how the person would interpret the Constitution, he would tend to vote against them and speak out against them, someone like Robert Bork, for example. But I think Kennedy falls into the category of a Justice Brennan, a Justice Goldberg, who would happily, if they thought it was necessary, make the Constitution up to date. The problem with that, for those who disagree with it, and it's a superb argument if you disagree with it, and that is there's an amendment clause in the Constitution, an amendment process, and that the founders intended, if they put that in the Constitution, if you want to change it, amend it through the proper formal channels. But the fact is, it's very difficult to do. And so when you have a Supreme Court or lower federal courts who want to take action themselves, that's how, to be honest, how our country has progressed over the years, in addition to legislation from Congress and sometimes movements of the president, as we can talk about with President Kennedy and civil rights and church-state issues.
Going back to JFK and religion, how did he interpret the First Amendment and role of religion as it came to his own presidency and time in office?
That's a great question. And the reason I think it's a great question is that it shows how personally President Kennedy both took and had to take the Constitution. And often when he would speak about it publicly and in some of his well-known speeches on church and state from September of 1960 to the Protestant ministers in Houston, Texas, which was a turning point, I think, in getting him elected and getting him over what was viewed as a handicap of being Roman Catholic and then becoming the first Roman Catholic president. And then we'll talk about civil rights too, and his famous speech in June of 1963. But back to the issue of church and state, what he said to those Protestant ministers, many of whom might have wanted to vote against him, maybe in the end they did vote against him, because the view in 1960, and particularly going back to 1928 when Al Smith was the first Roman Catholic at the head of a major ticket, was that people who were not Roman Catholic had a bias against Roman Catholicism. They had a bias against the Italians and the Irish and Eastern Europeans who came into this country as immigrants with that background. And they found Roman Catholicism, particularly because it was in Latin for its liturgy, that they had kind of a feeling of it was so mysterious and they didn't understand it. And many of them believed that the Pope would run the country from Rome if a Roman Catholic was elected. And so in Houston, President Kennedy says, the Constitution that I will take, the oath that I will take if I'm elected president, is the same oath I took when I went into the service. And here were probably men who had served in World War II and Korea, and he had immediate connection. He said, that's the oath I took to become a naval officer, where, by the way, he almost lost his life. He said, and no one asked me then what my religion was when I put my life on the line, and no one asked my brother, Joe Jr., who lost his life in World War II, what his religion was. And I've taken the oath now to be a member of the House of Representatives in 1947, a member of the Senate in 1953. So I take it personally, and I know what is meant by freedom of religion and no establishment of religion as a state religion. And that is that we are free to have our beliefs and that no one should be banned from public office because of a religious background or belief. And so he made it both personal, but also a constitutional interpretation that the Supreme Court was also taking up at the time with their ban, for example, on state-written, state-mandated prayer in the public school systems of this country. And that, of course, was controversial, but President Kennedy was asked about that very case. It was called Engel versus Vitale in 1962, and he was asked about it at a press conference. And he said, I obviously will look at it, but he said, I think what we need to remember is that we don't have a public religion, a state religion, but yet we all, if we want to pray, we pray in our homes, we pray in our places of worship, we pray in the schools. They all say, as long as there are math exams, there'll always be prayer in public schools and all schools. But his point was, parents can teach their children their religion, which is exactly what his mother had done for him.
And moving to the other part of his interpretation on the Constitution, he spoke to the National Civil Liberties Clearinghouse Annual Conference in 1959 as a senator, getting ready to run for president, talked about the solemn contract of the Constitution in the name of we the people. And he said that is an agreement that should be renewed by each generation. And how did that mindset go into his view of civil rights when it came to expanding civil rights in his era of the 1960s?
I believe that by that time, while he had taken a rather moderate approach to civil rights particularly for Black Americans, for fear that he would lose the South in running for president, or if he became president, he'd lose the Southern votes in the Congress to get through his New Frontier programs. And FDR had the same issue. So he'd been more moderate than someone more liberal like Eleanor Roosevelt wanted him to be, or Hubert Humphrey also in the Senate, what he wanted to be, going back to 1948 and pushing for civil rights, having a civil rights plank in the Democratic Democratic Party's platform. So Kennedy was being more cautious because he had to be in order to win the nomination and to win the presidency. But by the time we get to 1962, 63, particularly in the summer of 63, he sees the violence that's been breaking out in the southern universities, Mississippi and Alabama in 62 and 63. First of all, it's embarrassing in the Cold War to have that happen in our country, where we're saying we stand for freedom. We are the leader of the free world. He was the leader of the free world. And yet, when the federal courts made decisions that those southern universities, public universities, could not ban blacks from being admitted, that he talked to the southern governors and he said, one of them said to him, well, I have to follow the state constitution, and so I can't support having blacks go to these universities in our state. And President Kennedy, you can hear these on the tapes. He says, well, I have to support the U.S. Constitution. I took an oath to that. I have to support what the federal courts say. And then in his famous speech in June of 1963, about a 15-minute televised speech about civil rights, at the time these violent acts were breaking out at that time at the University of Alabama, and George Wallace, the governor there, was standing in the schoolhouse door trying to prevent blacks from being admitted. Kennedy said specifically that this issue of giving full freedom and rights 100 years after the Emancipation Proclamation, when he said, and yet the children and grandchildren of those enslaved Americans are still not free. He said, this is a moral issue for this country, and it is as old as the scriptures and it as clear as the Constitution. Equal protection for all. And that then pushes forward what would become after his death the 1964 Civil Rights Act, banning the segregation and the banning of black people in particular coming into public facilities that have any linkage to interstate commerce.
Thinking about how all of this has been founded in the Constitution and our constitutional rights, how has the Constitution been, a key part for holding our democracy together in the last 250 years? But also, where has it fallen short or even been in conflict with our democratic ideals? For example, the 3/5 compromise comes to mind for me. How would you look at the Constitution on where it's succeeded and where we've seen it's had to been amended?
First of all, it succeeded because of Lincoln and because of the brave men and women who fought the Confederacy that supported slavery and wanted to continue slavery. So Lincoln's support of the Union as at his first inauguration and second inauguration, and yet hoping by the second inauguration, as he could see the Civil War coming to an end and that the Union would win, the Constitution and our democratic republic would be preserved. He wanted to welcome back those from the South and talked about treating them with charity for all, malice toward none. Unfortunately, that didn't happen after his assassination, and there was a lot of, in the Reconstruction period, recrimination against the South. But those radical Republicans in Congress who didn't want to necessarily follow Lincoln's more moderate approach towards the defeated South, what those radical Republicans had done was pass the 13th Amendment, barring slavery and involuntary servitude. The 14th Amendment, part of which President Kennedy mentioned to those student interns, the Due Process Clause, the Equal Protection Clause, and something that is currently under consideration by the Supreme Court, and that is the so-called Birthright Clause that said that anyone born in the United States is a citizen of the United States and the state wherein they were born. And so that right now is under consideration because immigrants come to this country. They are not citizens in some cases, but if they have a child here, that child is an American. That's been the case since 1868 and the 14th Amendment. And then the 15th Amendment of 1869, another success in theory, was to grant the suffrage, grant the vote to people without regard to race. That meant that newly freed black slaves and free blacks would now be able to vote. I say in theory because Jim Crow then came to the fore in the South, and because of things like literacy tests and grandfather clauses and violence, blacks were not allowed to vote in practice throughout the South. It took the 1965 Voting Rights Act that is passed through our constitutional system supported by Lyndon Johnson as president, supported by Congress, and upheld by the Supreme Court, as well as the 1964 Civil Rights Act, which starts with President Kennedy and Attorney General Robert Kennedy, then supported by Lyndon Johnson and a majority of Congress, and supported by the Supreme Court, and then the Fair Housing Act of 1968, where our Constitution has particularly begun to fall, because otherwise you could say all through that time period, we were expanding the suffrage. And except for those who've committed felonies, including, people who we were recruiting in the suffrage realm, people who were 18 years old, whereby up until that amendment went through, you could only vote if you were 21 in most states. Kentucky and Georgia had an 18-year-old voting possibility, but that issue became very rife because we were drafting men at 18 to go to Vietnam, and they had no right to vote except if they lived in Kentucky or Georgia. So expanding the suffrage in age, obviously gender by the amendment in 1920 for women, for race, eventually for indigenous Americans. All of those are examples of the Constitution and our laws and our system and the rule of law working. But most recently, just the very fact that you have some people in Washington, led now by the incumbent, who believe that birthright citizenship, as clearly spelled out in the 14th Amendment, should not apply to people who are in this country with perhaps illegal, undocumented parents who then give birth to them. If that were to change, that would completely upend those who framed the 14th Amendment in 1868.
I appreciate that. And I think we're leading into the other question I have for you, which you mentioned the Richard Nixon event when the Republicans of the Congress went to him and said, listen, if you don't resign, we're going to impeach and convict you. That was Republicans speaking to another Republican president. Today, I think it's probably common knowledge that it'd be very rare for the Congress of this age, this current Congress, to go to the president with that type of ultimatum, to use their sort of Article 1 powers against the Article 2 president. And then on top of that, the president has now, the office of the president, according to the Supreme Court, has also now been given sort of blanket immunity for what they do as an act of office. So my question is, how do you feel these two situations, the partisan Congress that may be less willing to speak truth to power to their own party representative, and also the fact that the Supreme Court has sort of given the president much more authority to do what needs to be done without, basically the only way that the president can be rebuked is through Congress. And as we said, if there's not a Congress willing to do that, it kind of gives the president wide immunity. What are your thoughts on those two things and whether or not those are some of the more pressing issues facing our Constitution today?
So we want to begin by saying we don't want to indicate that no Congress has ever totally not countered the president. Let me put that in not double negative. So we don't want to think that in history Congresses have always countered their president, whether it's of the same party or not. So you can name even President Kennedy got a lot of legislation through because he had major party support majorities in the House and the Senate. The same with FDR is another example. So it's not unusual that you would have a Congress with majorities, even slim as they are today, of Republicans and then a Republican in the White House, that they wouldn't support their president and their party. What's different about this, I think, from President Kennedy's time and other presidential administrations is that you don't see but very few people speak out in Congress against the president of their same party. And in fact, they seem to be rather weak and enfeebled by him, because this is also quite unusual. The Republican Party right now is very different from most of the parties in our history, which have tended to be very, very big tents, very heterogeneous, and presidents would have maybe the support of one wing, but Another wing would be less supportive. And again, Kennedy ran into this with the Southern senators and members of the House. So really, it is the Trump party right now. And you don't have very many people who want to speak out against him or vote against him in the House and the Senate. The one exception to that in the second term was the Jeffrey Epstein legislation requiring that the Justice Department release all of the Epstein files. But other than that, there have been very few instances, particularly in the second term, of this Congress working at all to counter or check constitutionally this president. And then, as you mentioned about the Supreme Court, after the first term of Trump, the case that came to the Supreme Court about whether a president could be criminally indicted either while president, and the Justice Department in the Nixon era had said no. This is why Nixon was not ever indicted by the courts. He was viewed as an unindicted co-conspirator by the federal courts. So that's been around since the Watergate era of 1973-74. So the question then was, what about a president after he's president? Can he be criminally indicted? And this Supreme Court, very much created by Donald Trump, had said, as of a couple of years ago, no, that even a former president cannot be criminally indicted for any action he's taken as president if it falls under what they called his core constitutional duties. Frankly, in a concept of the rule of law, it's hard for me to believe that the founding fathers would have wanted the president of the United States to be above the law. There were two presidents who were at the Constitutional Convention in 1787 to, as it turned out, rewrite and create a new constitution after the Articles of Confederation were seen by some to be failing, and that we needed a stronger constitution. We need a stronger federal government. We had to add two branches. We only had a Congress under the article, so we needed to add the president, executive branch, and a federal judiciary. And those two were George Washington, who was the chair of the convention by acclamation and who would become the first president, and James Madison. And James Madison famously not only wrote really the first draft of the U.S. Constitution as we now know it and have lived under it since 1789 in what he developed as the Virginia Plan, which was an agenda to follow and, again, a rough draft of the Constitution that we have today. And he famously said then in the Federalist Papers, where he was writing with other founders to say, you, the states, need to ratify this. And they were writing these as editorials for the common newspaper in those days. One of the editorials that's now called Federalist Paper 51, he says, if men were angels, no government or constitution would be necessary. And then he says that we have to check the ambitions of officials and politicians, so that we have all sorts of different means of checking the three branches of the federal government, and then the federal government has some ability to have checks put on it by the states, and then the localities. So we have federalism, three levels of government, and in each level, three branches. So right there, you've got checks in the system. And then he also said we've got 2-year terms for House of Representatives, 6 for the members of the Senate, and 4 for the president. That means that they will be on different levels. And he used this term of ambition must be made to counteract ambition. When you have a president who is leaning towards authoritarianism, or at the very least leaning towards taking on more power than maybe the founders would have envisioned, and you don't have, at the very least, the 2 branches of government countering or checking him and giving him carte blanche to move forward while president and not be subject to the criminal law, different from civil, but not subject to the criminal law for anything he does, that he can make the case and they accept that it's under his core powers of the Constitution. You have a real problem, and to me, a turning upside down of how those framers in Philadelphia saw our new, at that time, constitutional system that worked, again, even through a civil war, was preserved and has worked up to the present. But we do have some concerns these days, those of us who study the Constitution and the presidency and the Supreme Court.
This is our final question. And thinking about these examples from the past and all of the scholarship and life that's been lived throughout the past 250 years with the Constitution, how can we look at that today as a document that can help us to continue to preserve and, in some cases, possibly expand our democracy for the next 250?
I just have to say, for those who've ever been to the National Archives and to go into that beautiful rotunda and see their protected environmentally and from light, the actual Constitution, the original document, and along with the Declaration of Independence, I get a real thrill and a chill when I see that document, and to think how different that was at that time, to have a democratic republic, first of all, where not everyone, of course, could vote in those days, but we have, as we've said, we've expanded the suffrage so that we've really taken in everybody 18 years and older. And that we have been, for all of our history since that Constitution came to be, we have been the beacon of light for the entire world. We have sent out our constitutional scholars to new countries. Let's say when the Berlin Wall came down and communism collapsed in Eastern Europe, we had, I call them constitutional Johnny Appleseeds. They went all over the world. They went to new democracies in Africa. They went to, after World War II, we sent our experts on constitutionalism to Germany and to Japan and to Italy, those axis powers of authoritarianism and totalitarianism we had defeated. And so I think, President Kennedy's leading the free world in the midst of the Cold War. First of all, I think he would have been thrilled to know that when the Cold War did finally come to an end, as he predicted it would, and that, as he said in Berlin, that we all needed to be free, and that someday Berlin and Germany and those behind the Iron Curtain would be free. He was right about that, and that we have been that beacon of light and that model for countries to follow. When we weaken our own model of our constitutional structure and the Constitution itself via either Congress not fulfilling its duty, or presidents going too far, or the Constitution being interpreted by the Supreme Court in a way that perhaps gives too much power to one branch or the other, I think it diminishes our role as a model of freedom and democracy in the world.
Thank you for that answer, and thank you for all your expertise as always.
Thank you so much for providing such great expertise on the Constitution and presidents. Really appreciate you having here today, Barbara. Thank you so much.
Well, Matt and Jamie, always your questions are superb, and I just am so grateful that you continue with this podcast, getting the word and the ideals of President Kennedy out to new generations as he had hoped to do.
Thank you.
Thank you. Thank you for listening to our latest episode in our special America 250 Summer Series. If you're interested in learning more about some of the items we discussed today, you can visit our podcast page for this episode. It includes links to all the items we mentioned today.
If you have questions or story ideas, email us at jfk35pod@jfklfoundation.org or tag us at jfklibraryfdn using the hashtag JFK35. If you liked what you heard today, please consider subscribing to our podcasts or leaving us a review wherever you get your podcasts. Thanks for listening and have a great week.